Most of us are probably very familiar with the Fifth Amendment to our Constitution, which basically has been interpreted over the years to allow us to have the right against self-incrimination. In other words, if we've committed a crime or not committed a crime, we have a right not to give further evidence, which would lead to our conviction. This has been a long-standing tradition in our country and has been consistently upheld by the U.S. Supreme Court for many, many years now, at least in the last let's say the last 50 years, the U.S. Supreme Court has said, hey, you have an absolute right against self-incrimination. Even if you have committed a crime, you do not have to aid in the prosecution of your own crime. You don't have to talk to the police. You don't have to talk to law enforcement officers. So generally speaking, the advice that everybody gives, even lawyers, pretty well most people that I know with very limited exception, will always tell you, hey, when you're in contact with the police, I simply want you to plead the fifth. But I got bad news for you. That can be the worst mistake of your life if you don't understand what I'm about to explain to you. Hi, I am J.R. Dukes. I am your host of the J.R. Dukes Show, and I do appreciate you joining me today. Today's topic is simply titled, Do Not Plead the Fifth. Now, let me give you a little bit of back history. First of all, the U.S. Supreme Court, as I was just stating, for a long time has always upheld that you do have an absolute right against self-incrimination of your person. There's a lot of Supreme Court case law that has been upheld stating what I just stated. Unfortunately, in recent years, the Supreme Court has changed and has been changing this philosophy. Specifically, I'm going to talk about a case that is relatively recent. The name of the case is Salinas versus the state of Texas. It is out of a 2013 case, and I'm going to get into it in just a second, but I want to give you a little bit of backstory. We are probably all familiar with the late but great Justice Anthony Scalia. He was an associate member of the U.S. Supreme Court, and I don't want to get off on politics on my channel. I want to protect you and your family from being a victim of the American justice system in which you end up serving prison time for a crime in which you did not commit. That would be a serious tragedy, and it's one of the main reasons my channel exists. How has the U.S. Supreme Court changed in recent years? Well, let's say since 1999, it has started changing considerably. First of all, if you look back at a case in 1999, the name of the case is Mitchell versus the United States. It was a split decision, 5-4. The reason it's noteworthy is although the conservatives lost on this particular decision, the Justice Anthony Scalia was quoted as saying something to the effect of, basically, if you are silent and you don't speak up, you are probably guilty. The example he used when he was making that reasoning was something to the effect of he has a 5-year-old son, and if he asks his 5-year-old son, hey, did you watch a particular movie? And his son just sits there and stares at him and goes silent. He basically said that the situation involving his silence, the fact that he is silent, essentially means he's guilty. You can read into that my child is guilty of watching something he shouldn't have watched. Obviously, that makes sense to people like me who's a parent. However, this is a crazy, crazy analogy, and it is definitely not looked at in the correct context by this justice. It was, in my opinion, a serious mistake he made because the fact of a 5-year-old watching a movie he shouldn't watch versus the real perils, the real dangers of having contact with the American justice system, it's just apples and oranges, to be really blunt about it, and it's nonsense. The Supreme Court nowadays, under the leadership of Anthony Scalia, has decided the following. First, the U.S. Supreme Court firmly believes that only guilty people use the Fifth Amendment right to remain silent, which of course is absolute nonsense. Before, the U.S. Supreme Court thoughtfully and correctly stated that the Fifth Amendment right protects guilty people and innocent people alike. Second, the U.S. Supreme Court wrongly believes that when a person waives their Fifth Amendment right against self-incrimination and agrees to go ahead and help the police, that nothing but good can come from that, which of course is absolute nonsense. The police all the time end up entrapping people that are innocent, people that did not commit the crime, and they end up tricking them. They end up using tools and techniques that they have in order to get them to confess to a crime that they did not commit and or essentially give up evidence that leads to their false conviction. The third point I would make is that the current conservative court essentially has arrived at the wrong judicial philosophy that simply states if you are silent, you're guilty. And as I've stated, that's complete nonsense. The reason why it's important not to plead the fifth is because of this 2013 case in which you have this individual named Salinas versus the state of Texas. And without getting too deep in the woods on it, the overview is as follows. Apparently, Salinas was accused of a double homicide. He was brought into police headquarters in Houston, Texas, and he was questioned for an hour, hour and a half, whatever it was. He was questioned for some time about where he was at the time the murders were committed. He was pretty well peppered, like any police interview is going to go down, with questions trying to see if he is guilty of the crime in question. And at that time, he went ahead and answered all the questions that the officers had for him. Well, the police told Salinas, hey, what is the likelihood that the shells that we found at the crime scene are going to match other shells, other bullets, other ammunition that we have found in your residence? At that point, Salinas just got quiet. He said absolutely nothing. He just sat there basically and stared and remained silent. At no time did he articulate that he wants to bring the interview to an end, that he will not answer questions, that he wants to learn, whatever. He didn't say anything. He just basically froze, remained silent. And unfortunately, in another split decision, 5-4, the U.S. Supreme Court went ahead and upheld his conviction, stating that the silence before you're arrested can be used as evidence of your guilt, which flies in the face of the American tradition. That has not been the case, at least in the last 50, 60 years, in the American judicial system. So you need to be aware of this, and you need to understand this. Basically, what happened in the Salinas case is that he was questioned, then he was released. When the ballistics came back showing that there was a match, apparently the bullet casings at the scene of the crime matched the bullet casings that he had in his possession at his residence. By the time they got around comparing ballistics, they went looking for Mr. Salinas to arrest him, and of course he was already gone. Fast forward approximately 15 years later, they found him, arrested him. They had a trial. I believe in the first trial, it was a hung jury. So they retried him. The problem is, in the second case, they went ahead, the prosecutors, and you know how much I love prosecutors. Prosecutors introduced evidence that he would not speak up during the police interview. And they inferred, and they told the jury, that you can infer that his silence speaks volumes towards his guilt. And unfortunately, the jury believed that, and they convicted him in large part on the testimony of the prosecution, stating that this was evidence of his guilt. It was brought up on appeal to the Texas Court of Appeals, and it was upheld by the Texas Court of Appeals. It was then appealed to the U.S. Supreme Court, and as I just stated, in 2013, in a 5-4 split decision in which the majority conservatives at that time won the day. They said that you can infer that if you remain silent, you are guilty of a crime, which is, in my opinion, complete nonsense. It flies in the tradition of our American judicial system and the way things have been for quite some time now. And frankly, it puts poor, uneducated individuals at risk because they don't know these rules. They don't know how to articulate their constitutional rights. And this is a shame. And it's sad, to be perfectly blunt about it. Lucky for you, you are hearing it from me, and you can spread the news to your children. You can spread the news to your neighbors and friends and explain this to them, that you need not plead the Fifth Amendment until and unless you are actually in custody and arrested. There's a set of rules when the police are investigating you, when you're downtown maybe talking with the police. First of all, you should never be downtown talking to the police. But if you are at their police headquarters and you're talking with them, like something on 48 hours, that is one set of rules. After you are physically in custody and you are basically arrested, is probably the best way to say it. There's a set of rules that you follow then. And essentially, once you're arrested, you definitely want to articulate that you will be invoking your Fifth Amendment rights against self-incrimination. Before that, there's another set of rules that you need to go by, and I'm going to talk about that in my next video. The purpose of this video is simply to articulate as clear as I can, and I'm trying to use as many layman terms as I possibly can so that you can understand what I'm talking about. I want to use as many layman terms as I can so you can clearly understand what I'm talking about. And the takeaway here is, before you're arrested, before you're actually in police custody, you need not take the Fifth Amendment. You also should not sit there silently, because that silence, according to the U.S. Supreme Court in this 2013 case, can and more likely will be used against you to prove your alleged guilt in a particular crime. In my next video coming out very soon, I will explain to you very clearly what you should do if you are questioned by the police in this particular situation. If you have any questions, feel free to reach out to me anytime. My email address is simply reachjrdukes@jrdukes.com. I always appreciate your time. Always be sure to watch my channel so you can develop what I call that free mind, and you need to learn the law so that you can keep your free mind free. I'm coming to you today from beautiful Zephyr Hills, Florida. Always remember to keep that mind free and never give up, my friends. I am J.R. Dukes.